Welcome to immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to the special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to better understand U.S. immigration policies and procedures better. My name is Chibi Satusa, and I'll be your host for today's important discussion, National Interest Waiver Strategy, Meeting USCIS Expectations in 2026. Now, the National Interest Waiver, as the NIW, remains one of the most attractive employment-based immigration options for highly skilled professionals seeking permanent residence without employer sponsorship. However, USCIS expectations continue to change, and applicants must present strong, carefully structured petitions that demonstrate eligibility. Understanding how adjudicators evaluate NIW cases, what evidence carries the most weight, and how to align a petition with current standards is essential for improving approval chances. To help us break this down, we are honored to be joined by Ira Katz, Esquire, an experienced immigration attorney who advises professionals across a wide range of industries on employment-based immigration strategies, including complex national interest waiver petitions. Attorney Katz, thank you so much for joining us today. We're thrilled to have you for this important discussion.
My pleasure. Good to see you.
Now, attorney, before we begin, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us on Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding national interest waiver strategies. Let's dive right in, attorney. Can you explain, or in simple terms, the three-pronged test and how it applies in NIW adjudications today?
Sure. There has been certain modifications to it, but let's dive in terms of what it is basically. Okay. The first prong is substantial merit, that the person applying, themselves has quote unquote substantial merit. Okay. And the second part is national importance, that the project that they are undertaking, for which we're waiving labor certification, which is a very cumbersome step in other types of green card petitions, has something of national importance. Now, I want to point out at this point, substantial merit, that hasn't changed. That part of the first prong hasn't really changed, okay? It really means that the person is qualified, okay, to undertake a national interest waiver, meaning either they have an advanced degree, a master's degree, or a PhD, okay, or they have some sort of exceptional ability, okay, meaning could be in the arts, could be in medicine, could be in STEM, okay, which is provable, okay. And the second part, national importance, is something that has changed, okay. It used to be the national importance was looked at as something that was important to the United States, but could be regionalized, meaning it was something that was important, let's say, to a community. Let's say, for argument's sake, Atlanta, okay? Or there were communities in Mississippi that had water problems. So, for example, the people that were able to clean up the horror that was the environmental problem with the water in Mississippi were looked at in terms of that would qualify, for example, from that perspective, as national importance. Now it has changed. So whatever the project that you're undertaking now has to have literally of national importance, has to be scalable, meaning that it has to be looked at within the context of the United States. Example from medicine being a simple example is a vaccine that will alleviate symptoms. That COVID vaccine is an excellent example of that. Okay, that is scalable, obviously, and scalable. Turns out it was scalable to the world. Okay, but if it was only a vaccine that treated a particular specific geographic region, that probably these days would not qualify unless you can make the case that later down the line it's applicable on a national basis. And what your project is essentially a test case for that scalability. Okay, that's the first prong. Okay, the second prong is that you're well positioned to advance the particular project that you're proposing. Okay, well positioned meaning that you have the education that meets it. Meaning, if you're, for example, a medical researcher, you have a background in medical research, you have the skills, you have a plan that you're putting forward that specifically addresses this particular thing. Could be, for example, in the case of a medical researcher, a laboratory plan. In other words, we are going to scale up our laboratory. I've run a laboratory like that during my career. Okay, so that is a skill that dovetails essentially with the proposed endeavor. Okay. Additionally, there is some progress within that proposed endeavor. In other words, it just can't be hypothetical. I have this great idea, okay, that will do X, Y, Z. Your idea, while way back, if you could explain it and essentially make a plan out of it by itself, is not enough today. Okay, there had to be some sort of step forward. I've met people that are going to fund it. I've discussed the issue with a major medical center, and they're interested. I have an MOU, a memorandum of understanding, that covers the fact that we're going to cooperate together. So that's sort of a step forward. The third prong is essentially you need to prove why you aren't going to undergo the labor certification. Okay, and in that respect, that has also changed. Okay, it used to be if you had the preparation for it, that was enough. But now you sort of have to connect it back. Okay, how will the waiver advance U.S. goals. Okay, I'm giving you a waiver. I'm allowing you in an expedited way to come into the United States. Okay, essentially the U.S. is asking, what is it doing for me? What is it doing for the United States if I grant you this visa? And you have to, the response to that, essentially, of course, in the petition, is that I am going to help by doing XYZ. Again, reference back to the project, and also that another interesting twist that we've been seeing lately is that the examiners are asking, okay, you may be doing XYZ, but why can't it be done outside of the United States?
Yeah.
Okay, why do you specifically need to come to the United States? So the answer could be economics. It could be I have funding there. It could be the facilities. It could be the researchers that I'll be working with. But you need to explain that as well in order for them to waive the labor certification.
Yeah. All right. Now, how can one clearly define the proposed endeavor, and what mistakes do applicants commonly make at this stage?
The biggest mistake really that's made in terms of that is applicants generally take their backgrounds, and in most instances, the backgrounds that we see are incredibly impressive people. Okay, there are scientists, there are entrepreneurs, there are researchers, and they've done amazing work. The problem is, in their petitions, they're not forward-looking. In other words, the United States wants to see, obviously, that the background is available, but a common mistake is they don't carry their background forward and say, because of my background, I am going to solve this problem. Okay, and it needs to be forward-looking in terms of short-term goals. In other words, specifically, I want to come to the United States to immediately do XYZ, to set up the lab, to make contact with other scientists, to discuss the possibility of cooperating with a particular center. Or in terms of an entrepreneur, for example, I just had a case where someone had a new application for AI, okay? And he came to me, speaking to me essentially about, okay, that he was involved in the discovery of one of the AI technologies, okay? As impressive as that was, I said to him, yeah, that's not going to get you a national interest waiver. What's going to get you a national interest waiver is tell me how, in the short term and in the long term, that AI discovery you're carrying forward, okay, into the project that you're doing, okay? Because the USCIS is essentially taking for granted, okay, that you have the background, okay? And now examiners are starting to sort of look at the petition backwards. They're looking at the petition and they're saying to the candidate, we want to see what the short-term goal, the long-term goal, and how you're going to go about accomplishing that first. If you don't have that, and you don't have that with specificity and a plan, we're not even looking at your background. Okay? We're just going to outright essentially either give you a RFE, request for evidence, or deny it. Okay? That's probably the biggest. Okay? Additionally, the other problem is you have instances where there are general statements made, and the person knows this, that the impact of their discovery, their technology, their lab, whatever it may be, is going to have an impact. Okay, the problem is the the researcher, for example, is terrible at quantifying the impact. In other words, the USCIS wants to know, okay, what is the quantification? The quantification is how many more units am I going to sell? Okay, how many people is this going to treat? Okay, they want, not in precise numbers, but they want a general idea of the impact of the project prospectively. Okay, and in many instances, okay, that is left out. And again, that's something now, particularly in 2026, that the USCIS is literally demanding.
Right. Now, Attorney, what types of evidence are currently most persuasive in NIW cases in 2026?
Okay. So first of all, I'll preface this by saying that all the evidence has to be viewed in terms of the three-pronged test. Okay? Meaning that when they look at, USCIS looks at the evidence, okay, there are certain types of evidence that don't prove one of the prongs. They may be very interesting, they may be important, but if they don't prove, they don't fit within that niche of one of the prongs, okay, it's extraneous, essentially. Okay. The USCIS evaluates the endeavor first. So the problem being solved has to be up front. Okay. And that's the type of evidence that you want to emphasize. For example, today, in many instances, we don't necessarily give a business plan per se, because it's different, much different than a business plan, but it's more akin to a feasibility study. Okay, sort of a mini feasibility study, where you take whatever the project is, okay, and you break it down in terms of the steps that it would need to accomplish the project, and you show, okay, if those steps are feasible, and then you back that with evidence. Evidence meaning it could be studies, it could be someone having tried this before and had something akin to it. Okay, and that is should be the main crux of evidence. In addition to which, you also want to get independent experts, okay, to essentially evaluate, okay, you and the project, meaning you in terms of your skills, how the skills are applicable to the project, okay, and how the project, okay, is important, and how you're going about it in something that is a new way or a better way or a not done way before. Okay, so instead of, for example, and again, the persuasive type of the evidence, okay, isn't essentially, well, I work with him, okay, and I know he's a really good guy and he's a really smart guy, okay, that gets tossed out the window. Okay, the fact that the person that is evaluating you has no connection to you, or has no commercial or any type of connection to you, but looks at it and says, that's a great idea, or that's a great way of going about it, or that's going to work, or that's scalable. Okay, that's extremely important evidence today.
All right. Now, how can applicants achieve or demonstrate future impact, not just past achievements?
Yeah. Okay. Well, the first step is you have to define the exact project itself. Okay. And that's very important. that it's not just an idea, okay? That it's not just a proposal, okay? You need to sit there and, again, put in place measurable goals, okay? And basically say, I am going to be able to do X, Y, and Z, or I propose to do X, Y, and Z. And by the way, it used to be that if you failed at proving whatever it is, okay, that was a problem, may have led to a denial in the past. No longer, no longer. If essentially you can prove your work, okay, and it doesn't necessarily work out the way you thought, there's a modification, you need to make a change, it didn't work in the laboratory, for example, but it's the old thing from school where in math you couldn't just write an answer, you have to prove your work. So that's what the USCIS wants to see. You have to prove your work, okay? And it's measurable. There are timelines, okay? And again, evidence of how in the future it's going to benefit the United States, okay? It's going to solve a problem. In other words, if the idea, for example, that I'm proposing to scale up, zero carbon types of engines, for example. We had a recent case. Okay, it didn't work out exactly the way it was, but it was approved because it had such an incredible impact. Would have such an incredible impact when go forward, and he proved his case, okay, step by step with projections and timelines and so on, okay, and the USCIS looked at it and said, that is exceptional, okay, that is someone with exceptional ability, and while they're not there yet, they're going to be there, and they proved their case. Okay.
Now, attorney, is USCIS favoring certain industries or fields when evaluating national importance?
Technically, no, but in practicality, absolutely yes. Okay, absolutely yes. They are favoring STEM fields, okay, because they're easy to quantify for them, and they're easy to adjudicate. Meaning, particularly fields that involve physics and things like that. Your proposal is, I'm going to do X. I have a timeline. I have the ability, and this is how it's going to benefit society. So for them, it's sort of an easier to adjudicate, and also they look at it in a much more serious way. Okay, I recently had a guy come to me. He wanted to do this. He's a brilliant guy. Okay, but his project was essentially, I want to make a better potato chip. Okay, and I said to him, no, I'm sorry. Well, I love potato chips. Okay, and I understand your passion, but we need to modify this in terms of the technology you invented for food service. I want to make a better potato chip, because they look at that sort of as not serious, okay, and a lesser industry. Healthcare, again, is also an industry that's very important, because it's very important to society because of the healthcare crisis that we have in the United States. Okay, and in terms of our budgets are breaking here, so anything that has to do with healthcare is given a preference. High impact entrepreneurship, in other words, things, for example, that are scalable, a new way to create manufacturing lines or things of that nature, and AI, but not AI in the sense of fictional AI. This is going to happen 20 years down the road. Applicable AI today. Okay. Now, that is a double-edged sword. Okay, because on the one hand, and I warn clients about this. On the one hand, right now, because this administration does not really care about displacing workers, okay, yeah, anything AI is golden. If there's a change in administrations, okay, and we start seeing complete dislocation of workers, okay, I'm not sure that it's going to be looked at as favorably. And the reason I even delve into that is because a lot of these petitions take years. Okay. So for now, it's looked at favorably. Okay. If doing these petitions, I would say it's something I would de-emphasize the fact, that people sit there and are proud of the fact, which, personally turns my stomach, but okay. But on a personal level, but like, yeah, oh look, I can displace 100 workers. No, yourself applying it, okay, I'm not sure it's the best way to go about it. So that sort of AI, everything today is AI, but that's sort of in quotes.
All right. Now, is it okay to include recommenders who are not directly connected to the applicant's work?
Yes, absolutely. As a matter of fact, you want the number of recommenders that are not connected to the work, who essentially you can prove have nothing to do with his work, are not related to his work, are not related to the institutions, whether they're, for example, universities or their workplaces or anything of that nature, because you want third-party independent evaluations. Okay, you want industry experts, you want government experts. Particularly, government experts are incredibly important to this process. If you can sit there and say to someone, "Oh, by the way, this whatever it is was evaluated by the Department of Health, okay, in the United States, and they liked it, okay. And by the way, I have a letter to that effect, okay." That is a tremendous piece of evidence, okay, and maybe worth more than all the other evaluations of your work, the recommendations that are available. Also, from independent professors.
All right. Now, attorney, looking forward or looking ahead, what practical advice would you give applicants to match their qualifications with USCIS expectations and improve approval chances?
Okay. First of all, as a preface, they need to start early. Okay. In other words, if they have in their minds that they would like to do this, like to come to the United States, okay, this is not from one minute to the next. This is planning. And this, I would say that planning at least a couple of years in advance to have the best chance, particularly at a national interest waiver, okay? Meaning looking at your career and saying, I'm going to gear it towards XYZ. Okay? Essentially, making sure that your degrees are in place, making sure that your skills are in place, making sure that that you're working towards that goal. I.e., if you have an opportunity, for example, to present papers, you have an opportunity to speak and have the spotlight on you. Okay, you want to amass a body of that. Okay, and you want to amass a critical body of that where other people are evaluating you, meaning, speaking in front of, for example, a couple of people versus speaking in front of, let's say, in the case of doctors, the National Academy of Pediatrics, okay, are two separate things. So if you have those opportunities, take them. Take as many as you can possibly get. Also, okay, and I say this to to clients who are essentially at the last minute looking for some way to get a national interest waiver. Don't do that. If you're passionate about something, okay, you're passionate about a particular field and you're researching in that particular field and you have an idea in that particular field, okay, take that as your project and move forward for that and build that over time. So you have a solid project. So you have the skills, the recommendations, the body of work. Okay, that will all fit into that petition. Okay. Also, you need to make sure, again, that whatever you're doing is scalable, okay, on a national level, okay, these days. And you need concrete examples of how you've improved something. In other words, you can't just sit there and say, oh, this is a better mousetrap. No, you need to quantify it. This gives you 30% more. This inoculates 100,000 people more. This allows us to save 20% in time. Everything these days, and this is what they're looking for, has to be quantified.
All right. Thank you so much, Attorney. It's been truly an insightful session so far.
My
For
pleasure.
everyone watching, this discussion about the National Interest Waiver strategy is not meant to create unrealistic expectations, but to provide clarity about what USCIS is currently looking for. Now, strong preparation, strategic presentation of evidence, and understanding adjudication trends can make a meaningful difference in your petition outcomes. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration related questions at no cost and engage with participating attorneys. We're also proud to share that ImmigrationQuestion.com is BBB accredited and ISO certified. This reflects our commitment to transparency, accountability, community education, and security. Now, Attorney Katz, based on your experience, how does a platform like ImmigrationQuestion.com help immigrants and immigration attorneys like yourself?
Well, I think it's excellent in terms of, in a sense, the potential client can essentially self-vet. They can get basic information, okay, and in the case of you guys, they can be steered to a very good immigration lawyer who specializes in the particular area, because in a sense, immigration has become so complicated today, okay, that, for example, I'm a business immigration attorney. I don't do asylum, okay, because my colleagues that do asylum, okay, specialize in this, okay. And these days, particularly, I wouldn't dare touch a case like that. It would be a disservice to my clients. So I think you do an excellent job of categorizing it, okay, giving basic information, and allowing the clients to sort of self-vet, okay, which I think are all very, very important, because I see a lot of clients who are sort of wandering in the wilderness.
Yeah, yeah. Thank you so much, Attorney, for those thoughts. Before we move into our live Q&A session, let's tackle an important question. What is a common misconception applicants have about the National Interest Waiver eligibility that you believe should be clarified before starting the process?
One of the big ones is that they tend to sort of rest on their laurels, meaning they come in, and again, all brilliant people, and they come in and they say, I won a particular prize, okay? And that's great, okay? But the what you do is throughout your career. In other words, if you've had a 15-year career and you say to me, 1 year I was honored as being the best researcher, okay, but I don't have anything else to back up the rest of my career. It's wonderful. It's a wonderful honor, okay, but you're not going to get, okay, the National Interest Waiver because A, okay, it's not throughout your career, and B, you're not necessarily carrying it forward to a project that will benefit the national interest of the United States. So they need to be have an understanding that it's an ongoing process for them. If their ultimate goal is to come to the U.S., this is an ongoing process through their career and through the preparation to come to the U.S. And you don't have to. I'll put it in very American terms. You don't have to hit a home run. Okay, they don't care about the home run. They care about slow and steady progress and showing the slow and steady progress.
Yeah. If you've just been joining us, we've been speaking with attorney Ira Katz on National Interest Waiver Strategy, meeting USCIS expectations in 2026. Now we're about to move into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. Please drop those questions in the chat or call us live at 516-703-3483 and we'll take as many as time permits. How important are expert opinion letters in an EB2 NIW petition, and can they really improve my chances of approval?
Yes. If there's a mixture of strong recommendations where people know you, okay, and can evaluate your work, okay, and a mixture of, as we talked about before, third-party experts who don't know you, okay, but are evaluating your work and the project that you're going to be undertaking in which you're applying for the NIW. Generally speaking, there's no particular number, okay, but for whatever reason, the USCIS wants to see at least 6 or 7, okay, but quality is much more important than quantity, and specificity in terms of the letters, okay, is very important. General statements don't go there. General statements, anecdotes don't go there. Real accomplishments that are documented in those letters, okay, are extremely important, particularly for the third-party letters.
All right. Valentina is asking, what exactly does USCIS mean by national importance? And how can I prove my work benefits the United States beyond my employer?
Well, it's really 2 parts. Okay, first of all, national importance is something that's of national importance to the United States that solves, essentially looking at it as solving a problem, okay? Whether it's an environmental issue, whether it's physicians that have essentially invented a new vaccine, researchers that have a new method of manufacturing that's less in terms of pollution. Okay, those are what our national interest of national importance means. But again, because of the way USCIS now, it can't be regionalized. It's something that is of national importance to essentially the country as a whole. Okay, it's not solving a particular very niche regional problem. It's solving a problem that's applicable to the country as a whole. Okay, now how can you prove work benefits in the United States beyond your employer? Really is in terms of what you do, okay, and how it's applicable to not just your employer, okay? Meaning, okay, if you work for an employer, you've come up with a technique, you've come up with a breakthrough, okay, where you essentially see that it's applicable to another field, or it's applicable as a wide ranging thing. Okay, that's part of the way. The other part of the way is that you essentially have to show that it's applicable. In other words, you took what you learned at your employer, you wrote a paper about it. You essentially applied it and said, well, not only could it do X, Y, and Z, it could also do something else beyond the scope of what my employer does. Okay, and this could be a breakthrough, in terms of that. Okay, because if all it does is have application to your employer in your particular set of circumstances, okay, it's just not wide enough in scope. Okay, essentially you have to think about the fact that you need to be able to prove that given that, you could take that and widen the scope of it on sort of a national basis.
Yeah. All right. Tariro is asking, do I need publications, patents, citations, or major awards to qualify for an NIW case in 2026?
Well, you don't need all of them, but you need some of them. In other words, it could be a combination of them. But you cannot sort of, again, as I alluded to before, you can't sit there and say, I won one particular prize, okay, in my career. That is not enough, okay? I have clients that have, you go and see Google citations that have pages and pages and pages of Google citations, okay? And, that is important, but it's also the quality. It's the quality. It's where it's being cited, who the paper is being written for, okay? So again, it's a balancing of quality and quantity. But the short answer is yes, you do. You need a combination of them. Yes.
Yeah. Now, recent reports indicate that a proposed ICE detention facility in Maryland has been paused following community protests and ongoing public debate over immigration enforcement and detention practices. Now, situations like this can raise concerns about detention capacity and enforcement priorities across the United States. Attorney, when immigrants hear about potential expansion or pauses in detention facilities, should they be concerned about an overall increase in detention capacity across the US and how that might affect enforcement trends?
I think the enforcement trends and the capacity are essentially two different things. The capacity right now, from what it looks like from the federal courts around the country and public pushback, even in extremely red states here, shows that these facilities are likely not going to get built, or not likely going to be built at the scale they wanted on. For example, this particular facility in Maryland was essentially slated for 1,500 detainees. Okay, and the community pushed back extremely hard. They pushed back in terms of basically saying we can't undertake in terms of electricity, sewage, environmental impact. We can't have this here. Okay, and then there's a second pushback, which is essentially the conscience of the community. No, we don't want people detained in what can be seen as, I don't even want to make the equivalency, but in these horrible places with no due process, with no health care, and with arbitrary detention. Now, can there be a guarantee that this is not going to happen? No. But the recourse in terms of going into federal courts shows us essentially that they're losing this. Okay, and they're losing this one by one, and they're also losing the public. So I kind of doubt that this is going to go forward the way it is. I think there's going to be a reform. I'm not saying they're giving up their unfortunate grand ambitions, but I think from practicality and from the courts, this is going to be modified in a very, very big way.
No. Thank you to everyone who joined us for this special edition webinar. And thank you, Attorney Katz, for sharing your knowledge and practical guidance with us. Truly an interesting session.
Thank you. Thank you for having me. I appreciate it.
Everyone else, you can always join immigrationquestion.com to ask immigration-related questions, stay informed about the policy updates, and register for upcoming live events. If you missed any part of today's important discussion, the replay will be available soon on Spotify. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Wednesday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye-bye.